Estate planning, rules of intestacy. What is intestacy and the rules of intestacy in England, Wales and Scotland? Dying without a will. What happens if you die without a will? Understandably, no one likes to talk about death, but dying intestate in the UK is something you really do want to avoid. Dying without a will. If you die without writing a will in England and Wales, your property and money will be shared out according to the legal default rather than your own express wishes. Dying without a will is known as dying intestate, a word with Latin origins, which essentially means without testament. It doesn't matter how close you are to certain relatives. If no will is made before you die, your assets and money will be allocated according to the same intestacy rules as anyone else. Intestacy rules. The intestacy rules determined how the estate of someone who dies without a will is distributed. The rules will allocate your estate to your family members in a strict order, depending on which relatives you leave behind. Usually, your spouse or civil partner will inherit the bulk of your estate, though unmarried partners won't inherit anything. Examples of cases to show how the intestacy rules apply in England and Wales. The following cases show how the intestacy rules apply in England and Wales. Married or in a civil partnership and has children. The husband, wife or civil partner keeps all the assets, including property, up to $270,000, and all the personal possessions, whatever their value. The remainder of the estate will be shared as follows. The husband, wife or civil partner gets an absolute interest in half of the remainder. The other half is then divided equally between the surviving children. If a son or daughter or other child where the deceased has a parental role has already died, their children will inherit in their place. Intestacy flowchart. This flowchart just shows how in England and Wales the rules of intestacy are allocated. Intestacy in Scotland. Intestacy in Scotland. The rules of intestacy in Scotland are different to those in England and Wales. A surviving spouse or civil partner is entitled to prior rights. This includes a share in the family home up to a value of $473,000, assuming it is in Scotland, and the partner was a resident in it at the time of death. It also includes furniture up to a value of $29,000 and other movable assets up to $50,000 if you have children, or $89,000 with no children. Whatever is left of the estate will then be divided up according to legal rights, which are shared between your spouse and any children or among other immediate family. If you have no spouse, your estate is shared among your children. If you have neither spouse nor children, your estate is distributed among your immediate family, according to the rules set out in the Succession Scotland Act. How to find out if someone has left a valid UK will. How to find out if someone has left a valid UK will. Ideally, anyone who has written a will should inform all named executors in advance and make sure they know where the will is kept, which could be a place of residence, a solicitor's office, or a bank, for example. But if someone has recently died and you want to search for a record of the will, you can find a will online through the probate service. A small fee is charged for each copy of the probate record. If you are a named executor in the will, you'll need to apply for probate, which gives you the legal authorization to deal with someone's property, money, and possessions. The process should be straightforward if you are a surviving spouse. In fact, you wouldn't need a grant of probate if you and your married partner owned assets jointly, but it may take longer for siblings. If you are still unable to locate the will, but you know it exists, you can report that the will is lost as part of your probate application. By clicking on each of the blue areas, this will take you to a link to find out more information to each service.